When I sat down on round one, I realised I was not giving you one final reference, which I said into play with the long list of factors which the tribunal had referred to. Can I just give you that reference now? It's paragraphs 9.335 to 9.341 of the final report, which is in bundle page 398, internal 233, and particular reference to 9.340. It's just a section, I needn't turn it up now, but where the conclusion on the impact of the merger on competition is given, and the various threads are drawn together so you can see the interplay that they have with each other.
Yeah.
That was the only reference I was going to give you.
While we're on references, can I just check that at some point, my understanding is that there's a transcript being taken, is that right?
That is right.
So at some point, presumably, we're going to be sent a copy of it.
Yes, I imagine.
I think
I'm surprised that you haven't.
I was asked to give permission for to be dealt with remotely, which it is being. So I assume that's what's happening.
If one has been sent to my clerk, it just hasn't got to me.
Not yet. Mine neither.
Well,
can somebody
we will,
check
between
that?
us, pursue that and ensure that you do receive the transcript.
Simply because otherwise I simply wouldn't have the facility to take down references.
I think it's
at
office
speed.
2. Pretty soon. It's not.
We all got in at 5 a.m. this morning in order to read the transcript.
that I had assumed, yes, but I apologise that it wasn't with you.
Just had to roll out pastry instead.
Can I turn to ground 3? I'm going to begin with the facts and then turn to the law. On the facts, the chronology is being prepared. As is indicated, we have made some additions to that provided by the appellants. I understand that in response there are a couple of comments which they've sent back.
Okay.
In the meantime, may I hand up a copy of the published administrative timetable?
Oh yes, that's helpful. Thank you.
So this was the prospective view of what should happen.
Yes.
So on the making of the thank you. The merger reference to phase 2. The CMA devises its own timetable for the procedural steps which must be taken. And it publishes that. And although this is marked draft in large capitals over the top, I'm told this is the published version. And you will see it doesn't provide precise dates at this time for the various stages which must be done, but it does tell the parties broadly what the expected progress of the investigation will be up until the 24-week statutory deadline. And you can see that the main waymarks include publication of an issue statement in early July, telling the parties what the CMA thinks the issues are at that stage, getting responses on that. And in early September, the main party hearings, and in mid-September, the deadline for all parties' responses to submit and submissions before provisional findings. Reporting there, that will include responses to a document which is known as the annotated issue statement and the working documents, which were in this case provided to the parties end of August. Again, the precise dates will be on the chronology, which will be handed up as soon as it's ready, with a response date of the 12th of September, although in the event I think an extension was given to the parties to the 13th of September. So that mid-September deadline was met as anticipated on the original timetable. And you can see that the next stage is early October, is to notify the provisional findings and, if required, possible remedies, which leads to further hearings if required, a final deadline for all parties' responses, and the publication of the final report in mid to late November, but in any event before the statutory deadline of the 29th of November. So that is the route. And of course, if and when that changes as a timetable, the amended administrative timetable is also published. So when the extension is made, obviously a revised timetable is produced. But up to mid-September, as you'll see when the chronology is produced, all going swimmingly and in accordance with this timetable. So can I then go to the reasons for the extension? You've seen it before, but it's in supplementary bundle tab 4, page 18.
Sorry,
It's supplementary bundle tab 4, page 18. And you'll see it in paragraph 2. Can I just draw out, obviously what is there said echoes the statutory language in section 39.3. That is, it considers, that's the inquiry group, CMA, considers that there are special reasons why the final report cannot be prepared and published within the reference period. Of course, those are the words of the statute, cannot be prepared and published. And then the reasons in paragraph 3 bear little consideration. They are expressed at a high level, that is true, but all the necessary ingredients are there. The inquiry group had regard to the complexity of the inquiry, that's the first element, the need to consider the issues raised by the parties and by third parties, including the broad scope of the submissions made by the parties in response to the annotated issue statements and working papers. So that is documents published in August, provided in August and responded to by the 30th of September, and the need to reach a fully reasoned final decision in the statutory timeframe, obviously in light of consideration of those issues.
anything else other than the broad scope of submissions is half of the course, isn't it?
Well, the complexity of the inquiry and the broad scope of the submissions. Obviously, in any case, you need to consider the submissions and you need to reach a fully reasoned final decision. But what that involves, obviously, is shaped.
But is that saying this is a particularly complex inquiry?
Yes, it is. And that the submissions are particularly broad.
Well, okay, it doesn't say this is a particularly complex inquiry, but okay, so...
I'll come to that, but just taking out the elements.
Okay.
The inquiry group considers that completion of its investigation and the publication of its final report will not be possible within the original reference period. Now, I stress those words, will not be possible, because of course that meets the test why the final report cannot be prepared and published. It is a high threshold, and it will take a lot to be able to say that. Obviously, in neither case, the statutory test cannot be prepared, or what is said here will not be possible. It doesn't say, well, it's not possible to produce a half-baked final report, which fails to consider the broad scope of submissions and fails to give adequate reasons for conclusions on them. What is being referred to in both cases, the final report, is a final report which does the necessary, which is to consider what has been said and to provide a fully reasoned final decision within the context of that case. Now, that notice provoked a letter on the 6th of October from Wilkie Farr. You have that in the same bundle, in the same tab, page 26. Complaining of the extension and saying, page 28, there are no special reasons, and taking issue with that conclusion. And that in turn produced a response from Margot Daly, and that is at page 33.
And just out of interest, at page 28, I mean, Wilkie will say this is not a complex inquiry.
They do say that, and you see that there's disagreement with that, both from the CMA, but also from the tribunal. I'll come to that in a moment. But their case is all perfectly straightforward. Of course, their case is all perfectly straightforward. It's a vertical merger, not a horizontal one, and there's no competition concern at all, is their case. Very simple, not at all complex. So the letter, as you can see just before the bold 1, heading 1, addresses the matters raised in 2 letters in relation to the extension to the statutory timetable in particular. You can see it recognises subject is subject to a duty of expedition, statutory duty, acknowledges that, and the group is of course aware of this duty and has already been fully taken into account in the group's decision to extend the timetable. And the following paragraph seeks to ensure its reviews are completed as quickly as possible. It's also important the duties should be taken as soon as reasonably practicable to ensure that CMA's information gathering and analysis is sufficiently robust and that the procedural rights of all parties, including third parties, are fully respected. So maybe an 8-week suggestion, but we'll adopt extension, but we'll adopt our final decision as soon as possible. Then the reasons justifying extension were set out in the notice. Having carefully considered your submissions, we continue to believe that there are special reasons. In particular, we note that CMA has received a substantial volume of representations from the parties in response to the AIS and working papers. This includes the submission of 2 additional frontier economics analysis models regarding entry and expansion and the quantitative analysis of input foreclosure, both of which were received on the 13th of September following a request for an extension. We also note that Cérélia requested on repeated occasions during the main party hearings held on the 6th of September that CMA should critically appraise its evidence on its file from third parties to address what's really perceived as a risk certain ambiguities could have been misconstrued. We believe our statutory duties require us to consider this evidence and these representations carefully, including by engaging with further evidence gathering with third parties who possess their own rights of due process where appropriate. And you saw that, of course, with the further evidence gathering and amongst other things, bells.
To pick up my previous comment, there's no reference there to the complexity of the case.
No, but there's a reference to the fact that the substantial volume of representations and
those are 2 separate
quantitative
things.
analysis.
But those are 2 separate things.
They are, but they come together in a fairly clear locus.
But when I asked the question previously, you said that the Wilkie Farr comment about complexity had been answered here. And it isn't.
Sorry, by the CMA, I said, I think, or I certainly meant to say, because that's not the final word. The next document, the next document is at tab 3 of the same.
Just before, can I just, looking at the indicative administrative timetable, mid-September deadline for all parties' responses, submissions before provisional findings.
Yes.
An application was made by the parties on the 13th of September for an extension of time.
No, the original deadline set for them for the responses was the 12th of September. They asked for a shorter extension to the 13th of September, which was granted, and that is when they did.
So that's not considered to be material in this.
Not. No.
And the 2 experts' reports from Frontier, one was entry and expansion, and then quantitative analysis of input foreclosure.
Yeah.
That's presumably on the basis that this is a vertical transaction.
Yes, it was.
And the entry and expansion would have applied either way.
Would have applied either way. And they were both provided on the 13th of September.
So it's the input foreclosure, which is the more grist to the mill than the entry and expansion. I mean, that's a fundamental difference.
It's a fundamental difference, yes. So I was going to go next to the witness statement of Margot Daly, which is in tab 3 and from page 12 of the bundle. Noting paragraph 10, CMA subject to a duty of expedition, being aware of that. And then over the page at 13, I don't know if I took you to 21 onwards, but I want to go to paragraph 17. Referring specifically to the AIS and the working parties being provided on the 26th of August, for discussing the time and implications of response and thinking at that time that the timelines were very tight. So far so good though. They indicated they may need an extension in the event it was only an extension of 1 day. I was conscious that additional time at this stage would have a knock-on effect, for example, when considering parties' responses to the PFs. My concerns were amplified after the main party hearing, which took place on the 6th of September, when it became apparent there may be a need for further inquiries in light of Cérelia's submissions, and then additional materials by the 14th of September. The group had sight of the combined submissions from the parties received on the 13th, following a short extension. These submissions comprised, there's all this set out, needn't read all that out. It includes those economic analyses, but much more besides. Very detailed engagement before the tribunal, because the tribunal wished to review this for them to assess the complexity or otherwise. All this material was produced, and we resisted the temptation to produce it all again in front of the Court of Appeal and invite you to feel the width of them. But there was a substantial amount, as both the tribunal and the CMA had said. And it's pointed out at 20, the additional material was voluminous, and the economic papers included complex analysis on the basis of vertical as opposed to a horizontal lens. And that is, as my Lord Justice Green just observed, a fundamental difference still being pursued at this stage. At the time, there was a serious appetite amongst the group, that's the panel of three who are determined the reference, to be able to have the time and space needed to properly consider the additional materials. I recall during one discussion speaking to a panel member about these responses, noting the economic papers needed to be thoroughly considered and assessed, which would require significant amounts of
I
time.
wouldn't expect any less of any panel member. I mean, this is all of these are very complex, all involve a great deal of material, they're highly contentious. The panel always wants the amount of time to, I mean, none of this is unusual. Now, it may not be the test. I mean,
but the fact,
Mr. Hoskins has sort of painted a picture that it has to be out of the ordinary abnormal. I'm not certain if that necessarily flows from the word special.
I'll come to the law, if I may. At the moment, I'm going to concentrate on the facts of what is said and what the view was taken. Of course, I accept there will always be a level of complexity in any motor inquiry, but whether or not the submissions made are so complex and so voluminous that it is not possible to meet the original time will be intensely fact specific.
Yes.
It is no answer to say complexity is your meat and drink. It will be true in some cases, it will not be true in others. It may be that the appellants were suggesting, well, this is all perfectly straightforward and it's not complex, but the CMA's view fundamentally differed from that being advanced by the appellants, and they wanted to be able to analyse the material put forward.
Does it come to this, Mr. Palmer, that the volume of material that was provided, leave to one side the complexity, let's just assume for present purposes it was a complex case, albeit perhaps no more complex than other cases. So the volume of the material and the complexity of the case is such that in order to do the job properly, the CMA had to have more time.
It was not
possible. That you say, that's sufficient to amount to special
that is
reasons.
capable of amounting in law to a special reason.
Because otherwise, as you said, it's all very well saying, well, you've got 24 weeks, but if in truth, in 24 weeks, even working, assuming everybody's working as they should be working, as opposed to simply sitting on their hands or whatever, assuming everybody's working properly, if in the 24 weeks all they could do produces something that was completely half-cocked, then that's not going to help anybody.
It's not going to help anyone, and I'll come on to the implications of that as a matter of statutory construction as well, to give you a flavour of what would happen if they felt, if they direct themselves, well, this is very, very complex, there's too much for us to handle, but that does not in law amount to a special reason, so we do not have power to extend time on that basis, and produced a report which, ex hypothesi, did not fully consider that material, but was half-cocked, didn't have full analysis of what had been put forward. The inevitable result would be an application to the tribunal for a failure to take material considerations into account, failure to consult further if they've reached conclusions which were not put to the parties, and so forth. And the result of that, ex hypothesi successful, if it is a half-cocked decision, is a remittal. And the result of a remittal is that the matter has to be reconsidered with a new report outside the statutory time limits. The statutory time limits no longer apply. What does apply, of course, is the ongoing duty to make a decision as soon as reasonably practicable under the general duty. What this is a recipe for less certainty what my learned friend's submissions advance is a situation where there's a positive duty, he says, just to do the best you can in the time you've got. If it's very complex, very difficult, very substantial, tough, and if the resulting decision doesn't stand up to scrutiny, well, that's a matter for a review. Well, that is going to lead to warped incentives on the parties, poor decision making, in the end less certainty, and extended timetables going well beyond the 8 weeks
I think what he
was taken in this case.
I think what he's actually saying is those may all be good reasons for an extension, but they're not special.
Well, I say I'll come to the law about what special is, but the answer is, in my submission, is they are, as a matter of law, special. And if I may, I'll
True, but I think when you're trying to, as it were, address the case that's made against you, I think it's probably accepted that everybody would prefer to see the CME do a good job, not a bad job. Or at least, that must be the presumption. But as I said, good doesn't equate to special. These are all good reasons for an extension, but they're not special. I mean, if Parliament had just simply said good reason, then we wouldn't be having this debate, because you would be probably galloping downhill.
I'll come back to the use of the word special, but in short, the word special reasons cannot be read in isolation from what follows, which is why the report cannot be prepared and published within the original statutory deadline. Any reason which means it cannot, not just we'd like a bit of extra time to do a Rolls-Royce job here, but we cannot, it is not possible. Anything which meets that threshold will by definition be special, because it is not the usual position. The aim is to produce and follow a timetable on that basis within the 24 weeks. Of course, you could always say, well, we'd like to do a few more investigations, we'd like to do this, in an ideal world we'd do that. That would not be enough to meet this test. And it will take something special to meet the test by definition, because it's a I won't say an extreme position, but it's a stringently articulated position.
And you also have to bear in mind, as I understand it, that this timetable, the 24-week timetable, applies to every inquiry, whether it is the most complex you can possibly envisage or the most straightforward.
Yes, it does.
So you see, this is why I'm pushing a little bit at this distinction between a situation where you just say this is a very complex inquiry, to which the answer is Parliament still intends you to finish complex inquiries within that timescale.
Well, within the timescale or the extended timescale, and again, that just begs the question. My respectful submission.
Begs the question of what's special.
Yes, I'll just finish on the facts, because there are a few more things to show you before I come back to the law. And just continuing with the witness statement, still at even this point, it wasn't lightly decided that there were special reasons. You can see on the 15th of September there was an update and highlighted that it may be necessary to extend that timetable to allow the case team time to fully consider the submissions made. So again, it wasn't a knee-jerk response here. They were testing it and seeing whether they could do it. And it was on the 21st of September, the project director indicated the case team wanted to discuss and the possibility of an extension. And the response was not to say, oh yes, that'll be fine, but to probe and understand the reasoning behind the need for an extension. And at 23, the project director indicated that there was a considerable volume of material to be reviewed, necessitating, no less a word, an extension. And it was clear from this discussion that additional time was required and that it would be impossible to give fair consideration to the evidence submitted by the parties without giving sufficient time to the task. It was also clear that we could not be precise about how much further time was needed at that stage, so that is 21st of September. And the week leading up to a further group meeting on 27th, an agenda was provided, and they considered that point. The request was made for an 8-week extension. Reasons were explained, consistent with what had been proceeded, and they went for the full 8-week extension on that point. and that was included in the final report with that explanation. So that is the facts, and before the tribunal, in assessing that, the panel made clear that it wished to review the underlying material to satisfy itself of the complexity of the exercise to be performed by the CMA in relation to that material. You see that in the judgment, so in the core bundle tab 7. At paragraph 318. Internal page 109.
This is core bundle page.
109. Oh, sorry, 152 of the bundle on the internal to the judgment, page 109. And you'll see that the tribunal extracted the same two phrases, so lighted upon in exchange with Lord Justice Snowden a moment ago. Complexity of the inquiry and the broad scope of the submissions are case specific, on their face rather vague. What emerges from a review of the state of the case at the time of the extension decision, in light of a review of Cérelia's responses to the AIS and working papers, that is the tribunal's review, are the following features. In contrast to Cérelia's position on ground 4 that this was a simple case, this was not a case where the issues were narrowing to a clearly defined and uncontroversial analysis of closeness of competition and alternative constraints. Instead, Cérélia was continuing to contest whether this was a horizontal case at all. That point obviously referenced in Margaret Daly's statement. It was contesting the nature of the overlap in the parties' activities. It was contesting the closeness of competition. It was contesting the evidence on customer and end customer behaviour. It was contesting the picture on alternative constraints. That would include entry and expansion. In light of our conclusions on grounds 1 and 2, it cannot be said that these were a function of errors in the CMA's process or thinking to that point. Again, that's an important facet of the appellant's case, that this was a simple case that they were advancing at the time. They're saying this was a simple case, but you, the CMA, have made errors all over the shop, which we are now being forced to correct with the submission of all these submissions, all these documents, all these analysis, all of which actually was, on analysis, groundless and failed to be rejected, and all of that upheld by the tribunal.
Yeah.
Consequently, it was open to the CMA to consider that it would need to revisit its analysis so far and to tailor its views on the merger through these various lenses. And this is not typical at this point, in order to ensure a fair hearing to Cérelia's case. The fact that the bottom lines in the case were clearly going to be broader than in a standard horizontal merger case, again that word broad, relating back to the breadth of the submissions, or indeed a standard vertical case, and that the CMA would need to justify both its own, brackets, horizontal approach, and its rejection, if that were to be the outcome as proved ultimately the case, of Cérelia's, brackets, vertical case, clearly added to the CMA's burdens in this case. Ideally, it would have been more explicitly particularised and dealt with, and that might have addressed Cérelia's objections at the time. Nonetheless, they support the proposition, and here's a finding by the tribunal having conducted that exercise, this was an unusual case in terms of how little common ground there was at that stage of the inquiry. And then they make the finding it was both necessary and appropriate for the CMA to carry out the further investigation and analysis that it in fact did, and no doubt Cérélia would have criticised it if it had not. And it concludes, it notes indeed that further consultation was later evidence of that, and that was exposed at 3-1. In light of these facts, we conclude that there were special reasons for the extension in this case. So that included, after a review, really testing the proposition that this was complex by reference to what had actually been submitted and what was and what was not in issue at the time.
So
It was an unusual case.
well, it became unusual as a result of the submissions that were received
Yes.
from the parties.
But so much was still an issue at that point, yes.
Because it can't be the case that if the CMA, sorry, I put this to you as a proposition, if the CMA looks at the start of an investigation and and says, this is going to be really complex.
Yeah.
That of itself can't mean that it says, oh, that's all right, we will have the full
Oh, no.
extended time period, because Parliament, if you can see it's going to be complex, you still have to get it done within the first time period, the 24-week
If it's
time period.
possible to do so.
Well, Parliament, as I said, complex or otherwise, if you can see it's complex, you just have to get resources onto it, etc., etc., etc.
I repeat, Mark, so if it is possible, and that,
Well,
that features in two respects
Okay, that's
in
not
the
what
statute.
That's not what the statute says.
It does in two respects, if I may. The first is the general duty of expedition. Obviously, the general duty is to do things as fast as is reasonably practicable. So there's an emphasis on practicability there. That's a pervasive duty which runs, and so it's an implicit assumption that it will be reasonably practicable to complete that report within the statutory deadline, indeed by the original deadline, unless, when you get to section 39.3, there are special reasons why that report cannot be. And we're in the realms of possibility there, cannot be.
So is
I don't
it
put it any lower than that.
Is it open to the CMA then at the start of an investigation to say, we can see this is going to be really complex, there's no way that we will be able to do it within the 24-week period, so we'll just give ourselves, at this stage, an additional extension of 8 and so
Let's take a conglomerate merger with 5 different product markets, all of which are complex, and you can see at the beginning that this is going to be a stinker. So the question is, does that, from that moment, entitle you to say this is special? Because it's not a normal merger, it's unduly, disproportionately
If
complex.
it was evident at that stage that it was inevitably going to be that complex, then yes. In most cases, in practice, it may not seem inevitable that that will be the case. It is only at the point where it can be concluded, not that it's likely to be difficult, not that it is not possible. There's no constraint within the statute at what point the section 39.3 power is exercised, but the test is cannot be produced.
Mr. Hoskins' test, that would be special because it's out of the ordinary. It's not the normal sort of transaction.
Well, the trouble with his test, which he adopted unusual at one point, as an acceptance of what the test should be, is there's a factual finding by the tribunal in this case that it was an unusual case,
I understand that. I mean,
which he doesn't dispute.
Yeah.
He didn't dispute when asked.
the word special, it doesn't say extraordinary, which would be outside of the ordinary, or exceptional.
Yeah. But you see, the reason I'm sort of pushing this a little bit is that certainly in the explanatory notes to the Act, I mean, they're obviously not the Act.
No.
But the examples that they give are things which occur during the period.
Yes.
I.e., they say, for example, illness or incapacity that seriously impeded the work of the group, reporting group, or an unexpected event such as murder of competitors. They don't seem to envisage at the start of the process the CMA just saying, look, it's just not practical for us to do this incredibly complex job in 24 weeks, therefore we will simply say this, right from the start we can see is special, therefore we've got an extra 8 weeks.
I suppose you would say you wouldn't necessarily be in a position where you could say this is the level of complexity and the weight of the material is such that we're going to need an extension. It's not something you're going to be able to say at the very outset, because at the very outset you don't know to what extent, for example, the provisional findings are going to be disputed by the parties and so forth. I mean, for example, if in response to the CMA saying that this was a horizontal merger, the parties had said, yep, we accept that it's a horizontal merger, then this whole process would have taken a lot less time than it did.
In that event, it's likely it would have been completed within time, yeah, because that was the particular point of difficulty and complexity, as noted by the tribunal, that it had to run down two
it had to deal with its own,
and further
opinion and that of the...
It was going to be broader either than a standard vertical case or a standard horizontal case, is their finding. So it's more complex on its own terms on each, and then you put that together, and they've got to do both.
But to be clear, I'm not focusing on that question. I mean, if something, as I think I said at the start, I mean, if there is something, for example, which is a complexity which is introduced by the parties in a way that you cannot anticipate or didn't anticipate, then that I can see more readily might fall within the definition of special reasons.
That's this case.
It may well be. What I'm doing is trying to test your much broader proposition, because your actual submission, I think, as a matter of statutory interpretation and approach, is much broader than that, as I understand you. You're saying, in any case, which the CMA can say, this is very complex, we won't be able to do it in time, we can treat it as special.
Of course, complexity is only one of the potential reasons which are special, but I do say it is a potential reason. But on that basis, again, I put it high, cannot, and it may be unusual that complexity on its own would be sufficient. But I cannot rule out a case where on its own it would be sufficient. No, I can't rule that out. But it's not this case where it's complexity on its own. What was specific about this case, in addition to the level of complexity, was the breadth of those submissions, the amount which had to be digested, analysed, investigated further, reported on, and so forth.
You see, I fully understand, and I was going why you might say the process that Parliament has envisaged is one which, by implication, expects people to cooperate with the CMA and, as the tribunal noted, to narrow rather than seek to narrow rather than enlarge issues.
Absolutely right.
Now, I fully get that, and that you say that is this case, you say.
Yep.
But your actual submission is much broader, and I'm trying to understand
again,
where your actual submission is going in terms of giving, because it seems to me that it is effectively giving the CMA, from the very start, in certain cases, carte blanche to give themselves an extra
I don't
period.
think as far as I'm aware, it's never been done, but I'll be corrected if it has. But from the start, I'll be corrected if anyone knows of a case. But as I say, it would have to be inevitable on that hypothesis. And the reason why, even to take Lord Justice Green's hypothesis of a complex conglomerate merger bound to raise all sorts of issues, nonetheless, it may turn out by the time of the issue statement and the annotated issue statement, actually, there's a fair amount of agreement on various issues, and that the real key issues which are being disputed by the parties are in far narrower compass. You won't know that at the outset. You won't know actually what's going to be an issue, however complex the merger is.
What are either expectation or rules or guidance or overriding objectives? Where does it say anywhere, if at all, that people who are the subject of this type of investigation have any sort of responsibility to assist narrow issues or anything else? I mean, does it? And if so,
there's various levels of assistance which can be provided. The backstop is the statutory notices requiring the provision of information, but rather than use those, often, as you've seen, all the inquiries made of retailers in this case are done on an informal cooperative basis rather than invoking all that. But
no, what I'm saying is, sorry, I'm not quite making myself clear. In normal litigation, there is an overriding objective, which says to parties, look, they will say what they say, but you have an overriding objective to conduct the litigation in a way which is efficient and expeditious, saves costs, blah, blah, blah.
yes. Is there an equivalent in the context of a CMA investigation?
You rather doubt it.
I'm not aware of one, but if I may just turn my back and see if anyone else is.
And it's very difficult to force a company. You have to measure it, you have to reason it. In the context of being accused of anti-competitive crime. So if there's a duty, and someone's going to say, well, you have to reason it.
Yes, we're not aware of any duty equivalent to in the civil procedure rules, because it's not a sort of formal litigation procedure such as that. Obviously, if there is foot dragging, that might result to an extension. Obviously, under section 39(4), if there's delay in providing information required, that stops the clock. But
what I'm
beyond
trying
that,
to get under the skin of is the tribunal's judgment of 318 sub 1 that you read out to us, or you directed us to, seems at the start of it to envisage that this is a special case because the issues were not narrowing. Instead, Cérélia was continuing to contest with his horizontal case at all. It was contesting the nature of the overlap. It was contesting this, contesting that, contesting the other. In other words, the focus of the tribunal's reasoning is this was special because the issues weren't narrowing; they were being widened by the parties.
Yes, I don't think
And
this.
what I'm trying to drive at is when we are looking at the question of what is special, what Parliament might have envisaged as being special, I'm trying to understand what would Parliament have envisaged for this process. Is it a process in which you can expect parties who are the subject of an inquiry like this to behave in a way which seeks to narrow issues, which is certainly in the civil litigation context what the court is entitled to expect? Or is it, I think as perhaps Ms Hoskins would say, it's to be expected that people will, who are the subject of this inquiry, will behave, quotes, robustly, unquotes, for which he might mean, well, what, they can be expected to take every single point.
Well,
I'm looking for some guidance.
no, there's different styles of engagement with the CMA. There's no overriding duty, of which I'm aware, requiring them to seek to narrow the issues. Some parties will, some parties won't. Some parties will take every single available point and more, and do so aggressively and consistently, and Mr Hoskins would say robustly. But that is not the basis of the special reason, that there is opposition or there is robust defence. The basis is grounded in the substance of what in fact was produced on this occasion and what in fact was required to be done in response to that in order to deal with it fairly. And if it is not possible to deal with that material fairly and produce a reasoned response to it in a decision because of the breadth of that and the unusual breadth of that, then that is capable in law, as a matter of fact and degree, I appreciate, but capable in principle of amounting to special reason. You are right, my lord, that it says that they were not narrowing to a clearly defined and uncontroversial analysis, but it doesn't stop there. It has to be read as a whole and goes on, not only to articulate the breadth of the issues which remained in dispute, but to go on to say that the battle lines were clearly going to be broader, say, than in a standard case, either horizontal or vertical individually, and here both put together, and that's what made it unusual. So the unusual feature identified is not just in the fact that there was a robust response, and not just in the fact that the issues were not narrowing, but a review of all the actual responses. In other words, they reviewed what the CMA was actually being faced with in terms of the response to the IAS, the working papers, the evidence being produced, the comments, the economic reports and so forth. And that was a judgment which they were able to reach. They didn't just take the CMA's word for it. And as an expert, experienced tribunal, including a member experienced in these sorts of investigations and having that expertise, that was a judgment which they reached. Now, in my submission, the approach to this is I fully accept what is a special reason is a term in a statute. It's a matter of the court to decide what those words mean. But once it is acknowledged that that sort of job to be done in unusual circumstances, characterised by breadth and complexity, such that you couldn't move from those responses to a provisional findings on the original timetable of early October, so about 3 weeks later, say. Once you reach that point, once you've reached the conclusion that is capable, depending on the facts, and as a matter of fact, a degree of amounting to special reasons, then the question is for the CMA and on review by the CAT or on further review by this court, the only question is one of rationality. And I make that point. This is not the job of the tribunal, although it did go so far as to say we agree that there were special reasons. That's not actually its job to go that far. At that point, it is a rationality review which it is conducting. And I take that from two places. One, the statutory language. This is the significance of the words if it considers that. And I handed my friend an authority this morning.
So the issue there is an issue for the CMA and not for the CAT.
Not for the CAT, subject to rationality.
Subject to the
Certainly
rationality.
reviewable. I don't seek to suggest it's not reviewable,
understand.
but by what standard? The answer is rationality.
The challenge here is purely one of law. If you're right that the reasons can, in principle, fall within the bucket special, then it's not suggested that on the facts this was irrational.
Well, that was suggested below. I didn't understand it to be suggested by Mr. Hoskins.
It is a point of law.
I was going to hand up. Maybe the court would still be assisted.
Just before you do that, okay, can I just ask you about special, something which I think probably reflects the concern of all of us. For my part, I'd be reluctant to see this battle between the parties and the CMA descend into the CMA having to conclude that the parties were acting unreasonably or unreasonably narrowing.
Yeah.
It's a very tight timetable. The parties are entitled to defend themselves. You have to evaluate.
Yeah.
On the other hand, if you consider that contrary to the way you'd have expected the case, it hasn't narrowed, for good reason or for ill, doesn't matter, then that might be a special reason. And it would be perhaps regrettable if it turned into you having to evaluate, because that would create an incentive on you to find bad reasons.
Well, that's precisely my submission, so I hadn't got this far, but when I deal with that point, it does. My own friend is right about the meaning of special reasons as a matter of law of not being capable, whatever the question of fact and degree in the circumstances of a particular case, but not being capable of amounting to a special reason. That would create a perverse incentive to hold back detail until as late as possible and to game. Now, Mr. Hoskins acknowledged that even on his case, I think he put it as actual proof of gaming might be different. The difficulty with that, though, is how is the CMA to embark on such an inquiry, given that strategy would be subject to
if you
legal
discover
privilege?
It's got enough things to do without doing that as well, you'd say.
Regardless of the motivation, about the timing or the substance, the amount of dust being thrown in the air, the amount of complication and complexity being actively brought to it, in reality, the motivation behind that, whatever strategy is informing that, is completely irrelevant. The CMA's job, regardless of gaming or otherwise, is to evaluate what is put in front of it, to deal with it fairly, to analyse it, and to produce a reasoned response. And it is completely irrelevant what the motivation for producing that material is to that exercise.
I mean, just looking at your indicative timetable, the bottleneck occurs after the main party hearings, when there's a deadline for the parties to make their final submissions. And you're really looking at a month from receipt of submissions to final decision. I mean, that's extraordinarily tight. And every hour, every day's delay, every extra document, every extra report puts that under pressure.
It is, but that is the ordinary
Yeah.
timetable. And the reason why that's not ordinarily completely impossible is the working papers are, if you like, early drafts of chapters.
Yes, absolutely.
That's what they're issue specific. You have different working papers on different issues, but they're like, they've begun to assemble the evidence, they've begun to express some tentative conclusions. It's nothing fixed at this point. That's the point of the consultation. You're seeking, but it's not a massive leap. You're not starting with the provisional findings with a blank sheet of paper. You're actively building on what has gone
After
before.
the oral hearing, that's the party's last chance to hit you between the eyeballs with their best case. So it's not unsurprising that you get a heavy wad of material.
Yeah, well, this was a week after, and again, a heavy watch in itself. Again, this is not a case where the CMA has ever said to anyone, feel the width of this, look at how much there is. I've got to read all this. You know, it's not one of those cases. It's the actual analysis of the substance of it, which gives rise to the difficulty, more than the difficulty, the impossibility of considering it fairly. And there is, in my special submission, nothing more special than something which means it is impossible to be fair. The very least that any party would require is that their submissions and their case is fairly considered. And ordinarily that will be done on that timetable, and the expectation is clear that it will be. But if it's not possible, then that takes you out of that category. I'm conscious of the time.
Yeah.
May I just make one or two further points on this before I must move on briefly to grounds 4 and 5, which on my case, of course, don't arise at all. But the next point is that at no point has the CMA suggested a lack of resource was responsible here. That was never identified as an issue. It had a very substantial and expert team. Of course, it's not infinite, but you don't want to overman a team. And that team must report to the group constituted to decide the case. That's the group of 3 identified at the start of the final report, following proper analysis by staff fully familiar with the case. Now, it's never said to have been a resourcing issue. It's not just that, oh, we haven't got enough economists to deal with this. What you need is to have analysis of all this material by the directing mind, with all that support from the staff, but by the directing minds of the inquiry, which will be at staff level, an inquiry director, and at group level, the ultimate decision makers, the 3 group members. They have to be across all of these issues. It's not the case of them being able to phone a friend or pull in extra resources. At that level, they need to understand the case. They are assisted by all the work done under the not under the radar, but under all the staff supporting and producing the analyses, and then in turn being directed as to what further analyses or further investigation they need to do by the group. It's never been suggested that the problem here was a shortage of people. What was suggested here is all of that just took that level of resource and took that time. Next point, it's particularly misleading for my own friend to submit by reference to a report of the number of cases in which an extension has been made, that something has gone wrong, as he put it. There's no evidence at all. The test here is nothing to do with how often special reasons are identified in any particular case. The number of other cases in which special reasons have been identified has no bearing at all on whether there was a lawful conclusion.
Well, and
special reasons were identified.
There was insufficient resourcing of the CMA, then the reason why there have been extensions in other cases is neither here nor there.
Neither here nor there. And
unless there's evidence, unless Mr. Hoskins could establish by evidence that there was a systemic problem, then that's...
We don't say that there's a systemic problem. And
well, as you said, it's not suggested a lack of resources.
Again, the test, this is the trouble with using words like unusual as a substitute for special. You can have unusual circumstances arising in a particular case and unusual circumstances arising in another particular case, which may or may not be the same. They may be completely different. And overall, it may not be unusual that special reasons arise. It is not a quota system or anything resembling it. The percentage of cases in which special reasons are identified is neither here nor there, and it's not a reason in particular for criticising the conclusion in this case.
So if Parliament had been told when it enacted the legislation using the word special, that in fact such a case would be met in 50% of the cases, you say it wouldn't be remotely surprised that would be what Parliament intended.
I'd say that would be a matter of complete irrelevance what they intended in terms of the frequency with which it's invoked. My own friend took you to a statement by a minister, which in my submission is inadmissible. It's not directed at the mischief. The mischief is known here. The mischief is the interests of certainty and expedition. That's what it drives at. We know that from the duty of expedition, the duty to have regard to the need for expedition, which is imposed by the statute. That much is clear. What he's really seeking to do is to seek to do a Sir Pepper and Hart style excavation of what special means by reference to an expectation of a minister at the time that in most cases this wouldn't be required. That is a matter of irrelevance as a matter of law.
It doesn't help because the minister 20 years ago, more than 20 years ago, may now be proved to have been completely wrong. I mean, it may be that it may be, I don't know. Merger cases now, 20 years on, are far more complex and detailed than they were in 2002. Given what happened, the explosion of disclosure in litigation over that period of time, it wouldn't surprise me in the slightest if that was.
I'm not remotely interested in what the minister said, to be clear. I mean, you've gone off and tilted at a windmill, if I may say on that. I'm trying to contrast the word special as used in the statute with what Mr. Hoskins says is the just grammatical opposite, which is ordinary or normal. Now, that's the submission that's made. So I'm just trying to test it. I think you accept that at the outset of a case, no matter how complex it appears, the CMA has to propose a timetable to fit it within the 24-week period.
Yeah.
And to get an extension, there has to be some special reason, which we can certainly see examples where something happens along the way, which is unexpected, because those are the sort of most obvious and easy examples that are given in the explanatory notes, for example. You say this case fits into precisely that sort of box.
Yes.
Because you say what was unexpected here is that there was a degree of volume and complexity introduced into the inquiry by the responses from the parties, correct?
That's the special feature. I wouldn't accept that unexpected or expectedness on it is the issue. Expectation again is irrelevant. You have to deal with the substance.
Okay. I was trying to make a constructive point, but anyway,
I'm sorry if I'm.
you take your own course. You put it into the box. You say that the tribunal was accurate in 3181 and entitled to, as a specialist tribunal, the respect for its judgment of what distinguished this case from the ordinary.
Yes.
What I'm just simply trying to understand is, you see, the tribunal did make at the start of 318 the statement, the references to the complexity of the inquiry and the broad scope of the submissions made by the parties are case specific, but on their face rather vague. And I think what they're driving at, and I'm trying to understand this, is if you look at the notice, you see, it said in taking this decision, the inquiry group had regard to the complexity of the inquiry, which seems to stand as a freestanding ground. And then it goes on, the need to consider the issues raised by the parties and third parties, including the broad scope of the submissions made by the parties. I mean, without wishing to sort of be too picky about the drafting of it, it seems to me what this actually should have said is that in taking this decision, the inquiry group had regard to the need to consider the issues raised by the parties and by third parties, including the broad scope and complexity of the submissions. Because what I'm trying to pin you down on is whether complexity is a freestanding ground which is available to the CMA at any stage of this process, irrespective of what the parties have said, as a quote special reason.
I understand the point. No, I don't suggest that there's a freestanding ground.
I apologise if I've not been getting that point over.
I apologise if I've been slow to
as
understand the question.
Because it seems to me that that would be an unusual reading of the statute as a whole.
No, I do not suggest that complexity in isolation, freestanding on its own, ipso facto special reason. No, it is, apart from being a very sort of imprecise standard as to what complexity is, it wouldn't be enough. What I'm trying to link the special reason to is the practical demand, the actual task which the CMA is faced with doing, which despite complexity may in the end reduce in compass to a narrower set of issues, or may not. But what is being focused on here, as is apparent from the evidence and is apparent from the tribunal's review, is the nature of the task and the time that they had to do it, and whether, based on the volume, breadth and complexity combined as a combination, it was possible.
Which came in with the responses.
Came in with the responses, exactly so.
Yeah, and that's the key. That's why I say you say makes this special.
Yes.
Because, and if I could put it in another and slightly pejorative way, so that Mr. Hoskins can come back at it. If parties to these types of inquiries decide to make things complicated rather than narrow, they can't then whinge about the fact that the CMA says we need a bit more time to deal with it.
Yes.
This is a special case.
Yes.
Okay. Have I got the submission correct now?
Yes, indeed. I mean,
And that's essentially what the CAT found in 319.
yes, that's right. And indeed, the point about they would have complained about it if they criticised the CMA if it had not done the further investigation and analysis that in fact did. It is exactly right. And of course, the force of the word necessary here, necessary to carry those further investigations, is it saying if you didn't do it, you wouldn't have a complete decision at the end of it. You'd have something which is vulnerable to review. That's what necessary means. It doesn't mean desirable. It means essential. And that is a flaw. So the counter case is you direct yourself, no, we can't extend on that basis. We're just going to have to bang out some decision, even if we can't don't have time to conduct further investigation, clarify Bell's position, Hanglands, all the rest of it. We'll just produce a final report because the statute so demands. Parliament intends us to do that instead. I say that cannot be right, because it would be vulnerable on review, have to be remitted, lead to less uncertainty and further delay, rather than complete the matter properly within the 8-week, actually a modest period, but 8-week extension period required in this case. So it's not some form of luxury, it is a necessity, and it's generated by that combination of circumstances. Just last few points on this. Various attempts were made by Mr. Hopkins to articulate what special means. None of them assist. He said extraneous events that cannot be foreseen. In my submission, that's a pure gloss on the statute. There's no basis to read very general words down in such a way. There's a reference to the South Yorkshire case. I'll just give you the reference for time reasons. In the judgment of paragraphs 299 and 305, Lord Mustall's well-known dicta about that. And that's a precise and a good example. In South Yorkshire, the word was substantial that had to be construed. Here it's special. These are fairly protean terms. They are chosen by Parliament because of their flexibility of meaning and their generality. What the explanatory notes say is that this term is not further defined, but it will include, and it gives 2 examples, but they're on the basis of will include. And the dictionary definition, again, is still too narrow and apt to be actively unhelpful in my circumstances, of out of the ordinary or unusual. But even if that were right, this was a case, as I've indicated, where the tribunal found in the facts it was unusual. So for all those reasons, we say ground 3 should be dismissed. The tribunal properly reviewed what the CAT had done and found it not to be irrational. May I just hand up one further authority just to make good a point that I made about if it considers that. It's Begum in the Supreme Court, which the court will recall was the British citizenship deprivation case. So it's another context, but there's valuable dicta at paragraphs 66 to 68. This is the well-known case of Shamima Begum, Secretary of State's decision to deprive her of citizenship and her right of appeal to SIAC. And what SIAC's task was on appeal, that's not a judicial review test, but on appeal in that particular context. Paragraph 66, you'll see the statutory test there is if the Secretary of State is satisfied that deprivation is conducive to the public good, not just if deprivation is conducive to the public good. The opening words, the Secretary of State may indicate the exercise of discretion confided to the Secretary of State, must be exercised by the Secretary of State and by no one else. There's no indication intended to be exercised by or the direction of SIAC. But SIAC can review the exercise of discretion and set it aside. 67, the statutory condition which must be satisfied before the discretion can be exercised is that the Secretary of State is satisfied that deprivation is conducive to the public good. The condition is not that SIAC is satisfied that deprivation is conducive to the public good. The existence of a right of appeal against Secretary of State's decision enables his conclusion that he was satisfied to be challenged. It doesn't, however, convert the statutory requirement that Secretary of State must be satisfied into a requirement that SIAC must be satisfied. And that's a further reason why SIAC cannot exercise the discretion conferred upon the Secretary of State. And then at 68, of course, appellate courts and tribunals cannot generally decide how a statutory discretion conferred upon the primary decision maker ought to have been exercised, or exercise the discretion themselves in the absence of any statutory provision authorising them to do so. they are in general restricted to considering whether the decision maker has acted in a way in which no reasonable decision maker could have acted, or other public law tests, in short.
I'm sorry, I think it's quite important to note the words "or has erred on a point of law."
Was there the point of law? Yes, no, of course. I don't seek to minimise that. As I say, if the reason it gives are not capable.
You're fighting the next case, not
Fighting-
this one.
Well, yes, but there you are. But the that may be right. There you are. You have that point. Once you're within the meaning in law, it's subject to a rationality review. It's not for the key point is it's not for the CAT or this court afterwards to substitute its own view as to whether it's special or not. Only to consider whether it's capable rationally of falling within that meaning. Grounds 4 and 5 I'll deal with briefly because time dictates that I must. If I may have until past, would that give you enough time? Ground 4. Now this in my submission is an extreme proposition that notwithstanding the finding of an SLC and detriment to consumers and damage to public interest caused by the merger, the consequence, it is said, of the CMA's decision to extend time in good faith because it appeared to it that there were special reasons for doing so. It turns out it was wrong about that because its reasons were not capable of being special reasons. It is said that the consequence must be that the merger is cleared. And my own friend compares the position to the case where the CMA simply provides no report at all within a statutory time limit and says this is in effect equivalent, and Parliament has contemplated the position that where there's no report at all within the statutory timetable, the merger must be cleared. And he said that is what Parliament intended. There's a missing link in my own friend's argument. That is a non-sequitur, in short, as assuming that the extension decision was made in good faith. The CMA, of course, would not have known at the time of producing the report that it was too late and it had no power to impose any remedy. Unlike those first two scenarios where there is a timetable, whether it's the unextended version or the extended version, it knows it must produce a report if it wants that power. But here what's said is through hindsight, we can go back in time and say that extension decision was no good, so the report must be treated as having been produced late, even though it was produced within the extended timetable which the CMA thought, in good faith, that it had done. Now the missing link is that, for that argument to work, the extension decision itself must be a nullity. It must have had no legal effect. Because if it had legal effect, then as a matter of fact, even if subsequently judged unlawful, if it had legal effect, then as a matter of fact, the statutory timetable was met because this report was produced within the extended period. So the focus has to be, is the consequence of a good faith decision to extend time by reason of special reasons, which turn out with hindsight not to have been special reasons, is a consequence that that decision taken at the time had no legal effect, or is it a nullity? Now that's a question which didn't feature in my learned friend's submissions, but in my submission it is essential. Of course, in the unlikely event that the decision was made in bad faith under section 39.3, so for an entirely extraneous purpose or for an obviously unreal reason, the special reason is we think the moon's made of blue cheese, whatever, something obviously ridiculous and perverse, then in truth it could be said that the decision maker never appeared to them that there were special reasons.
Can I just make sure I'm following the way you characterise the argument, because I certainly understood Mr. Hoskins' argument slightly differently. I think Mr. Hoskins says you only have the power to remedy the effects of completed or anticipated mergers under section 41 if you have prepared and published a report within the period permitted by section 39.
Correct.
He says
Accept that.
section 39 only allows an extension where there are special reasons. And if there are no special reasons, even if you look at it with the benefit of hindsight, section 39 didn't apply.
Yes, that's what he says.
Yeah, so I just want to make
So
that
to be
his
clear-
argument isn't it. It's nothing on his argument. You don't need to sort of ask questions about presumptive validity. He simply says
My submission is that is wrong. That's where he goes wrong in my submission.
So it's not jurisdiction. I mean, his view, I think, boils down to you just didn't, if he's right on special reasons,
Yeah.
you had no jurisdiction to prohibit at all because you'd come to the end without a decision.
Yeah, and it depends on it being jurisdictional in that hard sense.
Yes.
My submission is it's not. I fully accept that the CMA only has power to impose the remedy if the report is produced within the timetable permitted. Accept that, there's no issue there. I also accept that the timetable will be the permitted period would be the short period unless extended pursuant to 39.3. As a matter of fact, as I say, that's why I put the emphasis on good faith. The CMA did consider that there were special reasons. It acted, therefore, in reliance on that view.
he says validly extended within section 39. Good faith doesn't come into it. He just says either you validly extended or you didn't.
No,
It doesn't matter about good faith. It just you either had special reasons or you didn't.
He says good faith doesn't come into it. My submission is it does come into it. I'm limiting my own submission. I'm accepting that if there were a bad faith decision, very unlikely, but if there were, then the statutory condition that the CMA must consider that there are special reasons would never be met. It would not have been met, and it could never have had any effect because they were never satisfied that there were special reasons.
So let's assume good faith.
But yeah, exactly. And let's assume that it's not something obviously off beam or irrelevant, such as to be an abuse of power for some other reason. But beyond that, as a matter of fact, they did give notice to extend time. And the judgment as to whether that was lawful or not only comes afterwards. On this hypothesis, we have to assume that the judgment comes afterwards saying that was unlawful because those reasons that you relied upon are incapable of falling within the definition of special reasons. So then the next question is, what is the consequence of that finding? Does it mean that that decision was a nullity and never had any effect, so it was not effective to extend the timetable? Obviously, if it was not effective to extend the timetable, and the CMA produced their report at the time influenced by their belief that they had extended the timetable, then it would be they wouldn't have had power to act. But that begs the question: is the finding of unlawfulness reached later on such as to render it a nullity, so that it never had any effect? And that's the point which I dispute.
Yours are the heads I win, tails you lose, isn't it? Because when this distinction between ex-tunc and ex-nunc validity comes into play, prospective and retrospective, it means you don't unravel the past because people have relied upon it, but you might unravel the future. So the unlawful decision or the decision, even the valid decision, can have limited retrospective effects. But on this basis, it's one way. If it's unlawful and you act in good faith, then the decision stands. There's no ability to nuance it or create alternatives to it. It just stands, doesn't it?
Yes, it would. Well, it would be subject to the discretion of the court. It wouldn't automatically stand, no. My submission is that the tribunal were right ultimately to consider this wasn't an automatic consequence. It's one that they had to weigh and exercise their discretion according to all the circumstances. Now, on the first occasion that this happened, if they've literally proceeded on the mistake of law, I say the law does permit a tribunal or this court to weigh up the public interest in whether or not to decide that the consequence of that unlawfulness is that the extension decision was a nullity or not. Of course, if the court ultimately concluded that it had been unlawful and the CMA kept doing it in future cases, then that would weigh very heavily with any future court, saying, well, if you've just ignored the previous ruling, you've done it again, it's a nullity. That would be a matter of discretion, though, not a matter of automatic legal consequence.
So you say the statute could have different meanings or different application. Is this right in different cases?
No, I say that the consequence of unlawfulness can have different results in different cases by way of remedy. And let me just show you the jurisdictional basis for that. In the authorities bundle, at tab 28, This is, you haven't got the cover page, but this is apparently the index. This is De Smith on judicial review, and it's the latest edition. That's 2023 edition, 9th edition, that is, 2023. And we haven't copied, and perhaps we should have, the discussion which immediately precedes this, which is the reviewing the old state of the law, distinguishing between jurisdictional errors, to pick up language from Lord Justice Green, and non-jurisdictional errors, and the distinction between void and voidable decisions. So they have their locus classicus in now quite elderly decisions, such as anisminic. But the thrust of the Smith's analysis is that we've moved on from that, and courts have become increasingly impatient with the distinction, to the extent that the situation today can be summarised as follows. It starts with a presumption of validity. All official decisions, here the extension decision I would say, are presumed to be valid until set aside or otherwise held to be invalid by a court of competent jurisdiction. So those decisions, when made, can still have legal effect at the time that they are made. Under the terminology of void and voidable decisions, this proposition raises a paradox, namely a decision, although technically void, is in practice voidable. Such a paradox is, however, circumvented if we abandon those terms which lead to confusion, instead use the terms lawful and unlawful decisions. Decisions are thus presumed lawful unless and until a court of competent jurisdiction declares them unlawful. There's good reason for this. The public must be entitled to rely upon the validity of official decisions, and individuals shouldn't take the law into their own hands. These reasons are built into the procedures of judicial review, which require an application to quash a decision to be brought within a limited time, and a decision not challenged, whether or not would it have been declared unlawful if challenged, and whether or not unlawful for jurisdictional error retains legal effect. So does a decision found to be unlawful, but where a remedy is, in the court's discretion, withheld. The language of void and voidable cannot accommodate such an effect, as it would insist the void decision, being void ab initio, is devoid of legal consequence, and the voidable decision is capable of being set aside. You'll see the footnotes there, McLaughlin, which is in the bundle, and so forth. And that's the essential point I make to you. At the time the decision was made, again, assuming good faith, it had legal effect. And the legal effect of that was to extend the timetable, and the report was produced in time. If it is subsequently declared unlawful by a court, that is not the end of the matter, because the court then still has a discretion as to remedy, as to what to do. It can quash it and declare that it never had any lawful effect, in which case the report will be out of time. But that's not an automatic consequence. It's a matter that the tribunal, in this case, the court, can consider for itself. And you see support for that applying in this case. My friend was very rude about the tribunal's observation on this. But in section 120, which is behind tab 1 of the authorities bundle, page 57, two principles, two sides of the same coin. Section 4, the tribunal shall apply the same principles as would be applied by a court on an application for judicial review. That is that principle, which I've just shown you. And secondly, then, the competition may dismiss the application or quash the whole or part to which it relates. Now, of course, I accept in circumstances may can mean must, and of course that's not. I don't submit that's the end of it. It says may here. It's no more complicated than that. That is not my submission. But bearing in mind erosion of the distinction between jurisdictional and non-jurisdictional errors, between void and voidable, and the matter is simply being declared unlawful, then the question is, what does the public interest demand happen next?
I think the point that's going to be put against you is that that would be right in many cases where Parliament, through the structure of its analysis, has decided what the outcome is. You've either got the power or you haven't. You either prohibit the merger or you allow it to continue unimpeded. He says the argument lies in a proper analysis of statutory purpose. That's how you would exercise, the court would have to look at it and say, looking at the scheme, there is no scope for us to allow this to sail through.
So I reject that suggestion, and I reject it for this reason. It is impossible to derive anywhere from the statutory scheme a presumed intention by Parliament that should the CMA, despite it appearing to them that there are special reasons, subsequently be proved wrong about that, and that they act in good faith on the presumption that they will have power to take remedial action on behalf of the public by producing their report within that extended time. There's no parliamentary intention that nonetheless the public interest should then be defeated because the private interest of the parties, for certainty at an earlier stage, defeats that. Of course, there's a general public interest in parties in general, but in that particular case,
This might be the essence of it, really, isn't it? It's whether or not Parliament leads you to that conclusion or not.
there's nothing in the Act which contemplates this precise scenario. The scenarios it does contemplate is that where the CMA is in control of its own procedure and knows that it has a deadline to hit, it knows what the deadline it must hit is, and it either does or doesn't hit that deadline. The idea that it can proceed on one basis, on the basis of a good faith decision, because it appears to it that there are special reasons, subsequently saying, you know what, I don't think those reasons are special and a matter of law, the public interest should then demand that ex hypothesi anti-competitive merger should be allowed to proceed despite detriment to the consumer and the public interest is not something that Parliament contemplated at any point.
So, I mean, I understand the proposition that you say CMA in good faith grants, in belief that it has special reasons, grants an extension. If in the course of the extended period it makes orders, requires answers from people, the citizen can't just say, well, I don't think you had special reasons, I'm not going to comply. That would be no excuse. In a sense, in that sense, the order has interim validity.
Yes.
If a court ultimately says, actually, there was no power to extend because you didn't have special reasons properly so defined, that's the hypothesis for this. The normal circumstance is that at that stage, the original decision is treated as null and void, and that's apparent from one of the cases in the footnote that you've just taken us through.
That's right. The normal consequence when a decision is found to be unlawful, it is quashed by the court, but there are exceptions to that, and the exceptions are possible because there is a discretion. And discretion needs to be exercised judicially, obviously, but one of the circumstances, again, well established and not undisputed, is where it can be said that the outcome would have been exactly the same. This is a situation where the provisional findings were published before the original statutory deadline. We know what the CMA thought at that point. If they'd been forced to produce a final report, you know what, it's not provisional anymore, it's final, stamp. Hold on, we haven't been consulted, we're going to review you on that. You know, the decision that they made, the provision is, the decision that they ultimately made is to stop the merger, to say it had an SLC. You know, if they could somehow transport themselves back in time and say, oh, now that we know that we don't have special reasons and we're required to produce this report on this day, we know what it would have said.
So will this be the case pretty much with every situation in which this might occur? Because by definition, this will only arise, won't it, when the CMA has actually issued a report where there are remedies.
It all depends whether the CMA should know better, if you like.
But if
That
the
is relevant to the discretion. If the
Sorry,
court's
what I'm
already
saying-
decided that once, it can't continue to do it and expect to be sort of granted discretion in its favour on every subsequent occasion.
If the CMA takes extra time, says special reasons, and says that the merger can go through, but in fact didn't have special reasons to extend, who, if anybody, would have the standing or the ability to say, actually,
I'm not sure anybody would in those circumstances.
hence my point.
No, I'm not sure anybody would because there's no, if you like, the default position in the absence of a finding of SLC is that the merger is cleared. So again, I learned at one point, he may not have intended to say so, said there's no power to produce the report after the deadline. That's wrong. You can produce a report at any time you like, you just have no power to do anything in consequence. In
Therefore,
terms of
in a sense, by definition, we're into a world in which, we are always into a world in which as it turns out, belatedly, you can see the CMA has said this should not go through.
Yeah.
We want to impose remedies. And inevitably, therefore, you're going to say the discretion should be exercised to give effect to that finding in the public interest.
Well, not inevitably. I mean, that public interest will always weigh strongly.
When would it never?
Well, for example, if in this case the tribunal had decided these reasons are not capable, doesn't matter how much you've got to deal with, how complex, how substantial, how broad, it's just not special. And then the next merger case, which happened in the interim, the CMA gave the same reasons for doing exactly the same thing in the same way, despite knowing that they didn't amount to special reasons. Well, they couldn't expect to have a
No, but I
discretion
thought your
exercised
public
in their
interest
favour.
point was nothing to do with the conduct of the CMA thinking it had special reasons. I thought your public policy was it's against the public interest more generally to have a merger go through, which the CMA, however it managed to get there, thinks shouldn't go through.
There would be a public interest also in a public authority not knowingly acting contrary to a principle of law made clear by a court of competent jurisdiction. That has a public interest attached to it as well.
Yeah, but I thought your public interest was based upon the idea that if the merger shouldn't go through, if the CMA, however it's got there, says it shouldn't go through or for whatever reason.
Well, there's a strong public interest to a merger which is anti-competitive and detrimental to the consumer not going through. But I haven't submitted that is decisive of the exercise of discretion. I have submitted that there is a discretion that would weighed strongly here with the tribunal when it exercised its discretion, or notionally would have said how it would have exercised its discretion if it had found no special reasons. And I say it did not err in doing that. It took relevant considerations into account pursuant to a discretion which does exist and cannot be criticised for doing so. So that, in a nutshell, is my submissions on both grounds 4 and 5. I think you have the point. May I adopt my skeleton as well on those points? I'm conscious of the need to.
Arise, so, yeah.
Unless there's any further questions from the court. Thank you, very quick.
Yes, Mr.
I'm happy to say we've got an agreed timeline for you. Do you have copies? Sorry, Rob.
No, I think so. Thank you.
I'll go to some of the detail of this in a minute, but one of the first points I want to make is that the whole process of phase 2 is controlled by the CMA. It's entirely controlled by the CMA, and that includes the time limits. So the question of gaming, etc., has to be viewed in that context, but equally the question of statutory construction and the importance of the time limits has to be viewed against that backdrop. The CMA has complete control. Now, you've seen Ms. Daly's witness statement. You probably don't need reminding of it, but just to go briefly to the reasons for the extension. So it's a supplementary bundle, tab 3, page 13. The reason that the CMA decided to grant itself an extension was as a result of Cérelia's response to the AIS and the CMA's working papers. And there were 8 of those working papers. And you see that from paragraph 19 and paragraph 21. So you'll see in particular at 21, the project director provided an update in which he confirmed that the responses to the AIS and working papers had been received. And then next sentence, at this early stage it may be necessary to extend the statutory timetable in response to the AIS and disclosed working papers. So when you see the list of responses at paragraph 19, this wasn't Cérélia sort of creating a problem. All Cérélia was doing was responding to the CMA, the 8 working papers in the AIS. This is all controlled by the CMA. And as anyone familiar with mergers knows, because of the 24-week timetable, the time periods, the limitations that are set by the CMA are very strict. So in this case, sorry, this is the first time I've seen the agreed one, so bear with me while I just go through it. If you go to entry 10 on the chronology, I'm sorry, so these are weeks, so it's week 10, this is what happened in week 10, 22nd of August. CMA issues 2 working papers. The deadline was the 12th of September and we were granted an extension of 1 day. So we had 21 days to deal with those 2 working papers. And then if you go to the entry at the 26th of August 2022, the CMA issued the annotated issue statement and further 6 working papers. There were 8 in total. And you'll see that the original deadline was the 12th of September and extensions were given so that 13th and 14th, so 1 and 2 days. So in that case, the deadlines for us to comply with were 18 and 19 days. So the CMA has absolute power over the progress of its own investigation. And of course it does, because it's got to comply with the 24-week period. But this is how it controls parties. Now, it said that there was no problem at all in the timetable. The CMA was on schedule until the 13th of September. But all that happened on the 13th of September was that Cérélia responded to the documents that the CMA had put to it. 8 working papers and an AIS. And just so there's no doubt about this, whatever epithet one's use, let's call it complexity. Complexity wasn't introduced late by Cérélia because, as Mr. Palmer fairly recognised on his feet, the vertical against horizontal issue was an issue from the start. The CMA knew about it. It wasn't something new and unexpected. And indeed, in our submission, you can't readily distinguish or disentangle a notion of complexity from a notion of volume. They're necessarily intertwined in a sense. If something is complex, you'd expect to get more back from the merging party. And Mr. Palmer, on his feet again, fairly accepted that complexity on its own couldn't itself justify an extension. But if something is complex, you're going to have a lot of volume. It's almost inevitable. So if complexity on its own, the CMA accepts, cannot be a special reason, how can volume on its own constitute a special reason? They go hand in hand together. And what you see from this timetable is this was a normal merger procedure controlled by the CMA. And our submission, responding to standard documents produced by the CMA as part of its phase 2 inquiry, cannot be a special reason. It's simply part and parcel of the normal process.
I'm just looking at this. In week 14, paragraph 21 of this Daly's witness statement is this right? The project director first intimated, paragraph 21, that it might be necessary to allow the statutory time to extend the statutory timetable. That's the day after receipt of the 1 and days after receipt of the submissions from Cérélia.
That's right.
And then she says at paragraph 22 that there's something else happened on the 21st of September, which doesn't appear in your chronology. Is that significant?
The chronology has been agreed between us, but there's nothing's been sort of left out on purpose. You can.
No, I'm not
add
suggesting
that
it
in
has.
facts.
I'm not suggesting it has.
Sorry, I wasn't.
I'm just saying, so the initial request for the highlighting of the update seems to be on the 15th, and then that seems to be repeated on the 21st.
That's right.
No, it's not,
Have I got that right?
no request is made until the 27th. What
Yes.
happens is on the 15th, there's an initial indication after only 2 days of hanging on the material that it may be necessary, but there's no request. And then on the 21st, there's a further, having had the benefit of a week to go through the materials, and indicating that there's a considerable volume, and additional time was required, it being possible to give fair, so that it was a week or so before they arrived at that conclusion, having done their best. So that there's no series of requests which were then made. So that's what's being indicated there. So it's not in response to a new event on the schedule. It's just the fact that by then had a week or so to really try to get to grips with the material.
The internal thought process.
No, so, yeah, and see how complex it is. It's not an assumption. It's a result of work. So it's not a new event. It's just
No, I'm not. Well, sorry, it's a new event to this extent. The project director discussed with Staley on the 21st that she drew the conclusion it was clear that additional time was required. That decision was made, as far as she was concerned, in discussion with the project director on the 21st. Admittedly, there was then a group meeting where it was formalised on the 27th, but I'm not suggesting there's anything sinister about this. I'm just trying to get the timeline.
I can do no better than Miss Daly's witness
Okay.
statement.
it's
and
not
then we
her
can-
decision, of course. It's the group decision.
I get that.
Yeah.
Okay.
Yeah, okay.
In the context of this case, I mean, there's no suggestion of gaming. That's not this case. I understand the example that's been put of a party gaming or trying to game the timetable, but first of all, the CMA has power over its own timetable and can amply protect itself from gaming by the deadlines it sets. And equally, even if one does take the extreme example of a party seeking to game by holding everything back to the last minute, statutory construction cannot depend on an extreme example. To misquote a well-known phrase, bad examples make bad law. But what is quite clear in this case, there is no question of gaming. Nothing was introduced late by Cérélia. These issues were in play from the start. All that happened was that Cérélia responded to the documents that were put by the CMA as part of its normal investigation. In relation to the notice, it's a point that came up Mr. Palmer was making his submissions. I mean, we do draw attention to the fact that the notice, paragraph 3, does not say that this is a particularly complex inquiry or that submissions are particularly broad. So when one is trying to put some sort of meaning on what is special,
Before the cat, it was common ground that Miss Daly's witness statement could go in and was to be treated as an explanation, the explanation of the reason. So there's not a case in which it was opposed and said that you can't
no, that's
pull
right.
yourself up by the bootstraps. So are we really concerned with Miss Daly's statement?
That's right, but I'm not sure it says it's particularly complex either. That's,
no. I mean,
so it's the same. I think they're addendum.
Yes.
Maybe I'm missing a nuance, but I don't think Miss Daly actually adds very much to the notice at all. They got the responses. They thought there was a lot of work to do. They give themselves an extension, but I don't think there's any great distinction between the notice and Miss Daly. But absolutely, we didn't object to it. Complexity, if that is a valid reason, or volume, if that's a valid reason. We don't say either of them are, But I do make the point that Parliament has accounted for that, and you have this point well in mind. The 24-week timetable is set for all mergers, big and small, fat and thin, complex and simple. The whole point is it's supposed to cater for all mergers. That's what Parliament has decided. And it's decided that an extension should only be granted for special reasons. But the norm for all mergers, big and small, is 24 weeks. Mr. Palmer made the submission that it was impossible for the CMA to produce its report within 24 weeks, and that's what made this special. But it wasn't impossible by definition for the CMA to produce our report within 24 weeks. You have my submissions on the statutory interpretation and scheme. What the Act makes quite clear is the CMA must do the best it can in the available time. That's what Parliament has decided. And the suggestion that the CMA, sitting on a pile of information, will simply throw up its hands and not publish a report at all is not a credible one. Of course, if the CMA has to produce a report within 24 weeks or under a valid extension 8 weeks, it will do the best job it can and produce a report. The idea of impossibility to produce a report has to be read against that reality. In terms of what Parliament has assumed, we've been through this before, so I'll take it quickly. But of course, Parliament has assumed that parties will defend themselves robustly, to use again that epithet. And that must be the case because what we're dealing with is a situation in which parties have either completed a merger or have got so far as agreeing a merger, i.e. agreeing the commercial terms and seeking clearance for it. Any party in that circumstance is going to fight hard to be able to carry out their merger. So the suggestion that in some cases parties might actually say, well, we're not going to defend this, very much, or we're going to, what the phrase would be, play ball, or not put our best foot forward, again, is completely unrealistic. Any party defending its right to enter into this strategic and important commercial transaction will defend themselves robustly. And Parliament knew that and made the decisions it did against that backdrop. Mr. Palmer relied on the fact that he suggested it would be impossible to be fair. But again, that's priced into the legislation. The Act doesn't say, for example, the CMA must produce its report in as short a time as possible to ensure fairness. That's not the approach that Parliament chose to adopt. It chose to adopt a 24-week period. The CMA must do its best in those circumstances. And it was, the point was put to Mr. Palmer, is his position that if parties choose to make things complex, then they can't complain about an extension. But that's another facet I would submit of the robustness point. It's not parties choosing to make things complex. It's parties defending themselves robustly. It's the fact that all parties, merging parties, will defend themselves robustly. Therefore, Parliament take account of that. Therefore, the robustness of the defence cannot be special. Again, it's priced into the legislation. Ground 4 I can take quickly, which is even if there were no special reasons, does the tribunal have a discretion to nonetheless refuse to grant a remedy by way of quashing the final report? It's simply not correct as a matter of the legal framework, as Mr. Palmer suggested, that the extension decision must be a nullity. You have my submission, and that's why I can take this shortly. If the tribunal had found that the extension decision was unlawful, then the CMA had no power to adopt the final report to impose any remedy. And the appropriate legal question is that set out in Sonegi, the House of Lords case I took you to. The question is one of statutory construction. It's not one of good faith or some other concept. It's simply a question of statutory construction. And the whole point of the scheme, as I've submitted, is that the CMA will only have power if it acts lawfully within the time periods. It cannot possibly be suggested that Parliament intended the CMA to have power to intervene in a merger, to adopt remedies, to unwind it, if it has in fact acted unlawfully in granting itself an extension. It's an
If you're wrong
extraordinary
as a matter of construction, so there's the battle line. So if you're right, you're right. If you're wrong, do you accept then that it confers a discretion on the CAT as to how to deal with the unlawfulness?
But that's if I've lost, that's the point. If I've lost the point, that's where it leads to. But the whole debate about statutory construction.
Absolutely. So if you're right, that's the end of it.
That's right.
If you're wrong, do you accept that it then takes you into this more nuanced judicial approach, differentiating between lawful and unlawful?
That's what Synergy says. There's actually a two-stage in Synergy. We then have to look at prejudice, etc. I can't. You remember there's a two-stager.
I do.
I'm relying on the first stage.
Yeah.
If you get to the second stage, we're into ground 5, and you have my submissions on ground 5 about if the CMA didn't in fact have, if it gave itself an unlawful extension and didn't have power, the prejudice to the parties is incredibly extreme because they have to unwind the merger, and that's the Synergy test. So you have ground 5. That's where we get to if I lose on ground 4 by definition. Given the time, we trampled over grounds 1 and 2. You gave me a grilling. You gave Mr. Palmer a grilling. I'm not really sure there's much I can add at this stage, unless you have any questions on grounds 1 and 2. It's been well explored by the court.
Not on 1 and 2. I've got a question.
No, I don't think we have any questions on 1 and 2. Do we have any questions on anything else?
I don't think so. I'm just trying to get the timetable right.
Right.
Can I just ask you a timetable?
Absolutely, of course.
You said that it had been said. I'm sorry if this is, everybody else knows in the room knows this. I think you said that Cérélia had made its position clear on the vertical rather than the horizontal comparison at an early stage. And I'm just trying to identify when that was, and where we see it in a document.
Certainly.
There is a suggestion.
That was probably during phase 1, wasn't it?
Well, that's right. There's for example, I don't think this is in the bundle, but the CMA issued a briefing paper on the 17th of December 2021. Oh, sorry, it's our briefing paper on the merger that we gave to the CMA. And paragraph 1.5 of that briefing paper says the transaction is a vertical integration of Cérélia, a contract manufacturer of dough-to-bake products with one of its downstream customers, the Just Roll business. So my understanding is we completed the merger. We then sent a briefing paper to the CMA, which triggered all of this. And in the briefing paper that triggered the CMA's involvement, we said this is a
To
vertical
avoid a
merger.
phase 2.
So
To avoid a phase 2 and get automatic.
Well,
clearance.
yes, and this is pre-phase 1.
Exactly. Yes.
Absolutely.
Oh, right, yes.
So to follow it through, if we go back to the tribunal's paragraph 318, where they give their reasons as to why this is, these are the features which they say rendered this a special case. They say this wasn't a case where the issues were narrowing to a clearly defined, uncontroversial analysis. Cérélia was continuing to contest whether this was a horizontal case at all, etc., etc. But the main issue, which I understand rightly or wrongly, that what is said, there were complex economic analysis on the basis of a vertical as opposed to a horizontal lens, which is what's said in the witness statement. That's something which, is this right, you say had been on the cards for a very long time.
The issue of vertical against horizontal had been on the cards from the start.
So is this right? It would have been no surprise to the CMA when the materials referred to in paragraphs 19 and 20 of Mr. Daly's witness statement were filed, that they contained complex analysis on the basis of a vertical as opposed to a horizontal lens.
Exactly. That was our case. It's always been our case all the way through.
From a very long time
From
ago.
day one. From pre-day one, from before phase 1.
Pre-day.
Yeah. understood that. Right.
Thank you very much.
Anybody want to say anything else? Well, thank you all very much for your interesting and helpful submissions. We're obviously going to reserve our judgment. We will let you have it in draft as soon as we can, but I'm going to make no promises as to when. When you receive the draft, it's for the purposes of inviting the court to correct any typographical and similar errors. It's not for inviting the court to revisit the substance of its decision or the opportunity of making further submissions about the issues in the case. Could you please pay attention to the terms of the embargo at the top of the draft and ensure that is complied with? I think we all know now how important it is that it is complied with if we're to continue with a system where judgments are released in draft rather than going back to the old days when the court simply handed down the judgment and you didn't really have any opportunity to comment on what was in it or not. I don't think any of us want to go back to that. If you can possibly agree a draft order as well at the same time, we'd be grateful.
May we also perhaps resend the draft agreed confidentiality order
Yes.
and invite the court to make
Yes,
that order?
absolutely.
We made it.
Yes, and you invite us to remake that order. I think it's agreed.
It's the order made by the tribunal, but
Yeah.
the concern
No,
was
you
it wouldn't
mentioned
have
it yesterday.
continuing
Did
effect.
we not make it yesterday?
I think I indicated we would remake it.
May we send you the order to be
It just
sealed in that
needs to be
case?
sealed.
I'm grateful.
Right, thank you very much.
Thank you very much. Thank you.
Go on.